Hey y'all, it's me. It's your girl, the real deal. And you already know. Like, share, and subscribe. What's up, real deal? How y'all doing? I hope y'all doing okay. Y'all know I love you. I know y'all about to come here and y'all about to turn it out over here. Yes, over here in the chat. Now, what we're gonna do today, y'all? What we're gonna do? What thing that we don't do over here on this channel is use profanity. Okay, profanity is against the policy of YouTube, so we're gonna respect the Tubi. Okay, yes. Okay. We're gonna get into our content. Now, real deal, don't be upset with me. I had to go this route in doing this content because I have so much work to do. I got to put 5 more contents out there. And so this is not an easy job. So what I do want like for y'all to do is go ahead on, hit that like button and go ahead on over here in the chat. Continue as if I was here. Okay. Continue as if I were here so I can go back and read y'all reactions. Okay. I appreciate that. I love y'all, but I know I said I was gonna do the live for y'all, but I'm kind of sort of tired and out there in the heat. But I love y'all though, because I know I can depend on y'all to do what y'all need to do. Okay, the title of the content is Henry Dinkins 4XL accused of murdering 10-year-old Breasia Terrell, writes Judge LATHAM a letter. Yeah. I said Henry Dinkins, 4XL, accused of murdering 10-year-old Breasia Terrell, writes Judge LATHAM a letter. No, it wasn't a love letter. No. It wasn't a love letter. It was a letter pertaining to trial. So what happened was they said after citing laws concerning trial evidence, Dinkins wrote, I would have to say, Judge LATHAM, that the state didn't provide at least 50% of those exhibits until the day of the trial. And there are still others the state haven't provided to us, the defendant. Now that's not the letter. That's just a complaint. Okay. We're going to get into the letter. And now we're going to get into the letter. Okay. But Henry, you might not want them to get into all the 50 stuff like that, Ray, because it's probably going to eat you up. So what we're going to do, we're going to play this video, because I bring a video to all of my reactions. We're going to play the video, and then what we're going to do is go back and we're going to go over this letter that Henry Dinkins wrote. Okay. And by the way, I want to say pen letter. I go back and check.
With some breaking news we want to tell you about right now. The man on trial for the murder of Breasia Terrell has written a letter to the judge in the case. In it, Henry Dinkins says the state used, quote, deception and try.
Okay, we're going to leave that right there. We're going to leave that letter right there. This is the ink letter, that pen letter that Henry Dinkins wrote to the judge. Okay. So what we're going to do is I'm going to go over that letter. Okay. Letter. Okay. The letter says, Judge LATHAM, I am writing you with urgency. He wrote the letter September the 4th. And this September the 12th. So the 4th was like on a Monday, I believe. See, the first, second, third. Yeah, it was on a Monday. And the judge gave that letter. That's why it took him a while to, to go ahead on and plan everything for Friday. I am writing you this with urgency. Attention that the state has used deception and sabotaged this whole case to fit their opinion or theory, which that's what they supposed to do. Okay, sabotage this whole case to fit their opinions of a theory, which I have proof if given the opportunity to show you their lack of honesty to the courts and the public. Henry, you had plenty of time. Henry Dinkins, you had plenty of time to sit there and give and show the lack of honesty to the courts and the public. You had plenty of time, Henry. They asked you, did you want to talk? And you said no. You had a whole attorney there. You didn't even do it, Henry. First and foremost, the state did not obligate the court's order when my attorney filed for request for production and disclosed by counsel and pursuant to our rules of criminal procedures 214, stating the following items of evidence if in possession for preparation, the defendant to inspect copies of photograph. Wait a minute. Hold up, Henry. Hold up. I ain't never read like this. Hold up, y'all. Excuse me. Okay. He said, let me read it over, y'all. I apologize. It's not me. Trust me. First and foremost, the state did not obligate the court's order when my attorney filed for request for production and disclosed by counsel and pursued by our rules of criminal procedures 214, stating the following items of evidence if in possession and control of the state of Iowa are necessary for photographs or exhibits or any evidence the state intends to offer in evidence of the trial or where attained from or beyond belongs to the defendant. Rule 1.517, consequences of failure to make disclosure of our discovery. Rule 1.5171, failure to disclose or supplement if a party failed to provide information or unidentified a witness as required by Rule 1. What is this? 1.5004 or 1.508. The party is not allowed to use that information or witness to supply the evidence on a motion at a hearing or at trial unless the failure was substantially justified or harmless. The failure, okay, D, the failure to act described to rule may be excused on the ground that the discovery source is objectable. Henry. I can't even see this whole letter. Is that it? Henry ain't saying it. He ain't saying it. Oh, then it got right here. Judge Latham. Hold on, y'all. Hold on, y'all. Come on. But Henry, my thing is, why you bringing this up now? You could have brought this up in court. You could have brought this up in court. Y'all was you sitting right there by your attorney. What it was, your attorney didn't want to say this. Okay, let me go. I don't see nothing else on here, y'all. And then it got right. Hold on, Henry, give me a headache. Hold on for a minute. Okay, so it stopped at 1,500. Dinkins doesn't cite the specific evidence he claimed was not provided. See, that's what I'm saying. Henry wants to know.
City custom.
Hold on, y'all.
Cash card automatically adjusts to
Hold on for a minute.
earn you more cash back in your top.
I apologize. Okay. What Henry wants to hold on, y'all. Let me tell you about Henry. Henry slick. Okay, y'all, I apologize for that. I had to go out and come back in. I apologize for that. But I want to get into Henry Dinkins. What's really going on with Henry Dinkins with the letter. Let me explain to y'all this. Okay. The information that I just read from the pen letter, in that 3-page letter, that wasn't a 3-page letter I read, because I really wanted to read the whole 3 pages. I want to give y'all information. The letter that I just read, what I'm gonna do is download and read the whole thing after I give y'all this information. I said at first, after citing his laws concerning the trial evidence. Now Henry trying to tell the judge, which he should have said that then when he was sitting beside his attorney, but evidently his attorney didn't want to mess him up even worse than what it was. Judge led that the state didn't provide at least 50% of those exhibit. How he know? How he know? What is it? Who is he trying to punish in that court to let them finish looking at that information that he written? Who wants to read? Who wants them to show all of that stuff? It may be even worse. Something that'll hurt the family. So they might have felt like they didn't need to show that. They didn't want to show that girl up there. So Dinkins doesn't, y'all. When Dinkins got in here and he put the numbers down there, or the evidence that they didn't present, what Henry didn't do was Henry Dinkins doesn't cite the specific evidence. See, he think he's slick. He asked for something that he want to find out. So Dinkins doesn't cite the specific evidence he claimed was not provided to the defense. He didn't. That's why the defense attorney didn't say that. During the 13 days of the testimony, Dinkins' attorney Chad and Joel never claimed evidence was not disclosed. Do Henry know that? Do Henry know that? If that was a problem, them men would have said something, y'all. If that was a problem, the guys would have said something, but they didn't. So Henry, well, I don't know what Henry doing for or what's going on with Mr. Dinkins. He got to realize that's what his attorney there for. Dinkins didn't. He doesn't cite, y'all, the evidence that he claimed was not provided. He got to cite that. He got to tell her what evidence he's speaking about. Because Chad and Joel never claimed the evidence was not enclosed to them. That's over. During his closing argument, Chad did not raise the issue of states disclosing the evidence. Chad didn't say nothing. So I don't know what Henry talking about. This is sad. Reasia disappearing in the early morning of July the 10th, y'all, while visiting an apartment Dinkins shared with girlfriend Andrea Coverson. The 10-year-old girl and her younger brother spent the night with Dinkins, who is the boy's father. Reasia's body was discovered in a wooded area near a pond in a rural Clinton County on March the 22nd, 2021. Dinkins was arrested for violation of his SO status. The day Reasia was reported missing, was charged with first-degree murder and kidnapping in the early May of 2021. Dinkins was granted a chance of moving the trial to the Cedar Rapids courthouse in Lynn County as jury selection started on August the 8th. Dinkins asked for a bench trial. The trial was moved back to Scott County with Judge Henry LATHAM hearing the case. LATHAM is expected to give his verdict on Friday, Henry. If convicted, Henry would spend the rest of his life in prison. LATHAM did respond to the letter. The judge did respond to the letter, which he said, listen, let me turn this music off. LATHAM responds to the letter, and that is your judge, that's his judge, which he said he received Monday with an order saying he could not considered pro se motion as a defendant who is currently represented by counsel shall not file any pro se documents except for a motion seeking disqualification of appointed counsel. LATHAM also ordered direct the court clerk to provide a copy of this order and Dinkins' letter to all counsels of record. The judge ordered asked Chad and Joey to speak with Dinkins on whether any motion will be filed and set for a hearing. LATHAM advised Dinkins to work through his attorneys, and they end up showing a document. They showed a document. State of Iowa plaintiffs versus Henry Dinkins, order regarding pro letter. Defendant sent a letter to undersigned on September 11th. Defendant is represented by court-appointed counsels pursuant to Iowa Code Section 814.68. A defendant who is currently represented by counsel shall not file any pro se document except for a motion seeking disqualification of appointed counsel. The clerk shall provide a copy of this order and defendant letter to all cruiser of record. Defendant attorney shall, in other words, y'all, he had to work through his attorney. So I'm gonna let y'all see this. Y'all can't hardly see it. This is what Henry got to do. This is what Henry got to do. So I don't want y'all to see me because I'm doing I'm doing my hair. But I had to show y'all that, okay? Oh Lord, what is going on? Hold on, y'all. Okay, so hold on, y'all. Trying to put my trying to put my picture up there. Okay, so let's do that's documents. Yes. So Henry got to do this. He can't Henry. First of all, Henry had no business sending them to that judge. He wasn't supposed to send nothing. I'm gonna see, can I pull that document up for y'all, okay? Hold on for a minute. I'm see, can I pull this up for y'all? Okay, so okay, so I'm gonna let y'all see this information right here, okay? Okay. Hmm. Okay, let's see. Henry can dad, but trying to show you how this document. Hold on. This is what it is. Okay, hold on. Okay, hold on, y'all. For 1 second. I'm trying to download something for y'all. Um, wait a minute. What in the world is that? Jesus Christ. I don't know what it was. I don't know what that was, y'all. But anyway, I was trying to put a document up for y'all, showing that let me take this out. I was trying to show a document. Okay, hold on for a minute. Okay. Okay, this hold on, y'all. Let me type something in right quick. It ain't gonna take me that long, but it's some information that I want to give y'all right quick. And it ain't coming up for me. Hold on. Okay. Judge claiming did not share its verdict. Okay. But what I'm doing now is trying to pull it up this information what I just showed you. I said I know y'all not gonna be able to see it through the phone. So now, so what I'm gonna do, I'm gonna pull this up for y'all. Let me close this, and I apologize for this inconvenience. Okay. Okay, but anyway. So in other words, what the judge is trying to tell Henry Dinkins to do is don't don't send him nothing. He has to go to his assigned attorney. Now, if he had been his attorney himself, he could have spoke to the attorney that way, but he had an attorney to prove at that time, y'all, that they didn't prove that state didn't prove this and that and that and that. Now that's over with. That part right there Henry trying to do is over with. So like I told y'all what the judge said. The judge and I'll go back and read what y'all said, you know, what the judge said. And that's what the judge meant. The judge replied to him. So what I do is come back to them and reply to them. So on Friday, the verdict will be read. That's what took them so long. All this and that and that and this. So that's what the judge said. Yes, sir. Dinkins was a writ. That's what it said that Dinkins hold on, y'all. Dinkins granted a change. Dinkins granted a change of venue. I already said that. Okay, let me go back to here. I think I was done. After I showed y'all that document right there, that motion, that's what he's gonna do. And that's it. That's it. I wish I can get this picture to put a Henry right here. Hold on, y'all. I need to get this, download this picture. Henry not understanding. He trying. He understand. He don't want to understand. So what we gonna do? We gonna go live. I'm gonna go live because we got to talk, y'all. All right, y'all. That's all I got. That's all I want to bring in to let y'all know that the judge did respond to his letter, and the judge don't seem too happy about this, y'all, because Henry should have did this when he had his judge, you know, when he had his attorney there. See, Henry don't messed up. Henry should have never did that right there. Because just like I said, the judge responded back on him. Judge let him respond back to him. Sure did. And like I said, he respond to the letter, which he said he received Monday, with an order saying he could not consider pro se motion as, quote, a defendant who is currently represented by counselor shall not file any pro. He can't do that, y'all. He can't file pro se document expected except for a motion seeking disqualification or appointed counsel. LATHAM order that I read the court clerk to provide a copy of this order and Dinkins' letter to all the counsels of records. The judge ordered Chad and Joel to speak with Dinkins on whether any motion will be filed and set for a hearing. LATHAM advised Dinkins to work through his attorney, and they gave him the information. And if that's what he want to do, order regarding pro se letter. That's what the judge sent to him. That's all I got to give y'all today. Y'all like, share, and subscribe. I'm out. Bye.